Thank you for joining us today for what you need to know about small claims and the Copyright Claims Board. Today, we're joined by Maya Burchett and Dan Booth, attorney advisors with the CCB. If you have questions, feel free to pop them into the Q&A box. We'll reserve some time at the end of the webinar to answer as many as possible. However, we should note that we're unable to answer specific questions about individual cases or offer legal guidance. So with that, Maya, take it away.
Thanks, Holland, for the warm introduction. Thank you all for joining us. My name is Maya Burchett. I'm joined by Dan Booth, and we are two of the copyright claims attorneys here at the Copyright Claims Board, or CCB. Today we'll be presenting what you need to know about small claims and the Copyright Claims Board. So this webinar will cover a quick introduction to the Case Act, the types of claims you can file with the CCB, where to file a claim with the CCB proceeding structure and phases, where you can find additional resources, and your questions. As Holland mentioned, we're watching the chat, so please enter your questions in the Q&A function in the chat so that we can answer them at the end. Okay, so before we can talk about the Case Act, we have to set the stage about the issue and that the legislation was passed to solve. Before the Case Act was passed, if you had any type of copyright dispute, federal court was the only avenue to get a judicial resolution. This meant this was true no matter the type or size of your dispute, but many creators and users of copyright were excluded from federal litigation, and federal court can be a procedurally complicated, lengthy, and time-consuming process. Most importantly, it's expensive. We will be pointing out key differences between the CCB and federal court along the way during today's presentation. So why does this matter? Well, people with disputes that didn't have a high monetary value might not have the resources to pursue a resolution in federal court. Few attorneys are willing to handle small cases. In fact, the Songwriters Guild of America noted that such small claims and random infringements may seem unimportant, but taken in the aggregate, they have the effect on the livelihoods of individual creators akin to the infamous torture, death by 1,000 cuts. Dan is going to talk about how the Case Act came into being.
Thank you, Maya. So the Copyright Office has been the place to register your copyrights and to administer the copyright law for 150 years, but it just got into the business of copyright enforcement. So because going to court over infringement isn't a realistic option for most creators, and because copyright users who have reasonable defenses to infringement often get scared out of court too, just by the risk of high damages. In 2006, the Copyright Office was holding hearings on the issue of orphan works, and a comment came in from the Professional Photographers of America that called out all these problems, and it proposed that there should be a small claims court for copyright. So the office picked up that idea and ran with it and flagged the issue for Congress, which asked the office to further study the issue, and the Copyright Office released the small claims report that fleshed out the proposal. And then after several rounds in Congress, the Case Act passed finally in 2020, which authorized the Copyright Office to establish the CCB, a unique forum with a narrow focus on only copyright infringement and related claims. And we started accepting cases last June. So these are some of the key features of the Case Act, which we'll go over more as we go through. The CCB is designed to be a more efficient and more economical option to resolve copyright disputes. There's a cap of $30,000 per proceeding in damages. It's really a new way to enforce your copyrights or to protect yourself from bad copyright claims. The decisions are made by three copyright claims officers, they're called, who are all experts in copyright law. That's sort of the secret weapon of the Copyright Claims Board. David Carson was the Copyright Office's general counsel for 13 years, and he spent 7 years heading the copyright policy team at the Patent and Trademark Office after that. And Monica McCabe and Brad Newberg, the other two officers, both have decades of experience in copyright litigation. So they really understand what's at stake in these disputes. The CCB is a voluntary system. It's an alternative to federal court, but you don't have to be here if you don't want to be. You can always sue instead if you'd rather. And if someone brings a claim against you in the CCB, you have the right to opt out. So it's up to you. There's less money at stake, again, $30,000 cap because of the caps on damages. So there's less at risk, but it's a much more streamlined way to get those cases resolved. You don't need to have an attorney, which is huge. That saves both sides money. And you can represent yourself, even if you're a business entity. If you were in federal court with a copyright claim, if you're a business, you have to have a lawyer who you're paying to help you out. Here in the CCB, there are other ways to be represented without paying a lawyer. You can represent yourself, as I said, or you could have a law student or another pro bono group to help you through. And we've got resources to help you find those groups. The process is also streamlined in other ways. It's all virtual, so you're not showing up in a court. It's all done by this sort of Zoom type presentation or submitting things on paper or online. Discovery, which is the process where it's the part of a legal case where people just spend all their money in federal court. That's also narrowly targeted and heavily limited. So it's really just focused on the issues that are at stake in a copyright case.
Okay, so you have a copyright dispute. Before filing a claim with the CCB, there are several things that you should consider, including the type of claim you want to file, the type of proceeding, and the amount of damages you are seeking. Just a quick vocabulary note, a person who files a claim is called a claimant, and the person or entity you bring the claim against is called a respondent. We'll be using these terms as we go forward. And we'll also be treating this slide like a mini agenda. So we're going to start off by talking about the three types of claims that the CCB can hear. So the first type of claim that the CCB can hear is a claim of copyright infringement. When you own copyright in a work, you have the certain exclusive rights to use the work. Copyright infringement occurs when a copyrighted work is reproduced, distributed, publicly performed or displayed, or made into a derivative work without the permission of the copyright owner, if the use does not qualify for an exception, such as fair use. Now that we know what copyright infringement is, we can talk about who can bring a claim before the CCB. The CCB can hear claims from the legal or beneficial owner of the work in question. So what's a legal and beneficial owner? Well, a legal owner is the author of the work who owns those exclusive rights we discussed in the last slide, or an entity who has received a transfer of those rights, by example, from a license. A beneficial owner who has transferred one or more rights we discussed, but retains some of the advantages of ownership, such as the right to receive royalties of the work. Another important thing to discuss is who you can bring a claim against. The Case Act specifies that you can bring a claim against a person or entity residing in the United States. And so here we have an example. Dan is an author who wrote a novel about his adventures selling vintage records entitled My Life in Vinyl. Dan is on a music novel forum when he discovers that MB Publishing, a company he has never heard of, is marketing and selling his book online without his permission. Dan can file an infringement claim with the CCB. So Dan, who's the author and legal owner of the works, discovered that one of those exclusive rights we discussed, the right to distribute his book, is being infringed by MB Publishing, who, for our sake of this example, is a company residing here in the United States. So Dan found out his work is being infringed. He knows he can pursue his claim before the CCB. What should he gather before he sits down at his computer to file a claim? Well, potential claimants should gather their copyright registration information, their copyright ownership information if they're a beneficial owner, contact information for the other party, and any key details about their dispute. So one of the key differences between the CCB and federal court is the registration requirement. In federal court, you must have a registration to pursue litigation. Here at the CCB, you can either provide that registration number, or you can provide an application service request number, sometimes called an SR number, for that says that you have a pending copyright application here at the office. I just want to note here that a complete registration is a registration application where the registration fee and deposit or copy of the work has been submitted to the Copyright Office. So one of the other most important things that you need when you're filing your claim is details about your dispute. You want to provide a detailed description of why you think that your copyright was infringed. And the more details you provide in your claim, the better. You do not need to provide a legal argument in your claim, just a statement of the facts and circumstances that support your claim of infringement. One of the key differences between the federal court and CCB is that the CCB is staffed with those experts that Dan mentioned. You don't need to become a lawyer to file your claim. And the most important thing that you can do is to make sure that you describe the facts and circumstances surrounding your dispute. You don't need to worry about a legal argument. Your description should help the respondent and the CCB understand how you think the respondent got access to your work, any relationship you have to the respondent that's relevant to the claim, and the similarities that you see between your work and the respondent's allegedly infringing work. Copyright infringement cases are the most commonly filed claims at the CCB so far, but Dan is going to walk you through the other two types of claims that the CCB can hear.
So the other type we can talk about right away is sort of the flip side of an infringement claim, which is a claim for a declaration of non-infringement. The CCB protects copyright users from claims that they were infringing. This is sort of a way of just saying, no, did not. You can ask the CCB for a declaration of non-infringement if someone accuses you of infringing and it's not true. For instance, if you have a license to use the work, or if it's fair use, or if they don't own the copyright in the first place. And so there are two big things, I guess, you should keep in mind for these types of claims. First, the burden of proof is on the respondent to show infringement. So the respondent is the person who accused you of infringing. You bring a claim saying, no, I didn't, and you're asking the board to sort it out. If your accuser can't show that you infringed, you win. Now, if the accuser can show that you used the work and that it used a work that was infringing, you could still show that you have a defense that's valid and still win the claim because, you know, this is still an opportunity to prove that you have the rights. Also, this is a claim for declaration, not a claim for damages. So for this type of claim, the CCB can clear up your rights, but we can't award you any fees on this, any award of damages. So it's the alternative, but it's a good way to get your rights cleared up so that you can proceed without a legal cloud over your head. So who can bring a claim for a declaration of non-infringement? You have to prove that you have a genuine dispute with the other party. If it's not really in dispute, you're just anticipating that somebody might threaten you at some point. That's not really going to cut it. If you've received a cease and desist letter or a demand, or there's a public statement that you've been infringing, those would be some classic examples where this could apply. It has to be a United States party that made the threat, made the accusation. But interestingly, if they file an infringement claim against you, then you could raise a non-infringement claim against them in the same proceeding, a counterclaim. That's the exception. Also, for this claim and for all the other claims, not only does it have to be a United States entity, but it can't be a state or federal government entity that you're bringing the claim against. And you also can't bring a claim if there's another claim pending in court or it's already been decided in federal court. So if you're being sued for infringement, you can't then bring a claim in front of the Copyright Claims Board to say, I'm not infringing, and sort of try and raise the exact same issue in another forum, unless that court stays that proceeding, holds off on that proceeding so that it gets decided here. You just proceed in one forum at a time. So here's an example. Let's say, again, I've started to start a blog about photos that are used on vinyl album covers, The Secret Life of Forgotten Vinyl. So if I'm a blogger and I get a cease and desist letter from a photographer of one of those record covers, someone saying, I'm the author of these photographs, I'm the photographer. If I believe that it's fair use, that what I'm doing is allowed, then I can file a non-infringement claim and try to get the CCB to agree with me. So before you file the claim, this type of claim, you're going to need contact information for the respondent, just like you would any other claim. Here in particular, though, you want to be able to provide information that shows that there is a genuine dispute between you and the respondent about whether you infringed or not. That's the key thing for any type of declaration from a court or from the CCB. And so in addition, you want to show that you've got a valid claim to the extent you can. So if you want to prove that you had a license, then you might supply a copy of the license or the agreement or emails between you and the respondent that shows that you had permission to use the work. If you're contending that someone else owned the copyright, explain who did, and maybe show that with some documents as well. In our example, if I want to show that I've been making a fair use of these photographs, then I'm going to want to show that I'm doing something different with the works than the photographer did. And I want to show that the way I'm using the work is reasonable. So I might provide a PDF of the website showing the use in context. And I also want to show that I'm not harming the market for the copyright owner's work. So I might include facts about why there are different markets as I see it. So the other type of claim we can talk about is a misrepresentation claim. Now that has a very specific meaning in copyright law related to takedown notices and counter notices. So this is the third type of claim you could bring in the CCB. A lot of infringement claims are about online use. And under the copyright law, if you see someone infringing your work online and you want it taken down, you don't have to go straight to court or straight to the CCB. You can ask a middleman called an online service provider to help you out. Online service providers are entities that provide internet access or other online services like a web host, an internet search engine, content sharing engine. These are places that store and refer to online material, provide access to it, make it available, or even provide links to it if it's available online. And so the DMCA, which amended the Copyright Act, the Digital Millennium Copyright Act, sets up what's called a notice and takedown system. And it works like this. The service provider gets a notice of infringement saying that someone used your service to post my work without permission. So then they have to take it down, or they might be on the hook for infringement. And they can't put it back up unless the person who posted it sends a counter notice saying it's not infringing. This was misidentified as infringement, or it was a mistake. Now, they will, however, keep it down after the counter notice if the person who sent the takedown notice in the first place files a lawsuit or files a CCB claim within a couple of weeks. So that's sort of the background on misrepresentation. But the thing to remember, of course, is in the course of the takedown notice and the counter notice, both parties are making representations about what really happened. And so you may be able to bring a misrepresentation claim if someone was saying something false in those statements. So someone, again, residing in the United States, you could bring a misrepresentation claim against them if they make a knowing misrepresentation to the service provider, a knowing false statement of fact, and the service provider relies on that misrepresentation to take down a work that wasn't infringing or to restore work that was infringing. And if that hurts you, then you can bring a claim for misrepresentation and you can seek damages on that claim. So one example, if I've got my book, my ebook, My Life in Vinyl is up on social media website, and I didn't put it there. So I submit a takedown notice to the website. Well, they'll take it down, and then the poster, MB Vinyl Lover 15, who posted the content, they'll tell that poster it was removed. And then that poster, Maya, aka MB Vinyl Lover 15, can send the website a counter notice saying, hey, I own this content. It's fine for me to put it up. Well, I can then file a misrepresentation claim alleging that her ownership statement was false, a knowing misrepresentation. The flip side is that what if I see a chapter from my book, My Life in Vinyl, up on the website for MB Publishing LLC? I used to have a deal with MB Publishing. They were authorized to put it up there, but I've decided I want to go with a different publisher. If I send a takedown notice to the publisher claiming the use is unauthorized, and they actually have a license to publish the work, then they could file a claim against me alleging that my statement was a knowing misrepresentation and that I was just trying to mess with their business. So these are some of the important elements that you've got to keep in mind, and that you're going to need to prove these things. So to the extent you can, you want to present as many of these facts as possible in your claim, so it's clear to all parties that you've got a valid claim. Describe your dispute, describe what the takedown notice or counter notice was. You might attach a copy of it and explain what it was that was false. What was the misstatement? What was the false statement there? And explain why it was false or incorrect. And explain, it was taken down or it was restored because of this false statement and how you were harmed. And again, provide the contact information for the parties, and that's all you'll need to get the claim started.
Okay, so we're back at our mini agenda. Now that we know the 3 types of claims that you can file here with the CCB, we will be talking about the 2 types of proceedings available at the CCB. There are 2 tracks of claims, a standard track and a smaller claims track. The standard track is for claims that are pursuing damages to the full CCB limit of up to $30,000. The smaller claims track can be used for claims that are for up to $5,000. The smaller claims track has a few key differences. It's more streamlined than the standard track. There's less discovery than the standard track, which Dan will talk about later. The focus on conferences between a copyright claims officer and the parties are a little bit different. In a smaller claims track, there are more conferences with a copyright claims officer than a standard track. We'll be highlighting the rest of the differences between the standard track and the smaller claims track as we go. But the takeaway here is that you have 2 options. If you're seeking less than $5,000, there is an option that's faster with less discovery.
So the last thing we're going to focus on here in this example would be, what are the damages? What can I get out of this dispute? And so, as we said, the monetary awards cannot exceed $30,000, and it's $5,000 in that smaller claim proceeding, which is more hands-on. For infringement claims, the claimant can be awarded either their actual damages plus whatever additional profits the infringer made that are attributable to the infringement, or they can be awarded statutory damages, which is an amount that the board considers reasonable, up to $15,000 per work. That is 1/10 of the amount that they can award in federal court in statutory damages. And in federal court, the sky's the limit on actual damages. In fact, if the copyright was registered more than 3 months after the work was published and after the infringement started, then the cap is even lower. It's $7,500 per work and no more than $15,000 per proceeding. So again, lower damages in that case. If you've just discovered an infringement that was going on for months and you're just now going to file your registration application, then that's the limit that you're looking at. There's also other differences between damages here and in federal court. There, they consider the willfulness of the infringement, and we don't take that into account here. We also can't award punitive damages or any awards based on physical harm, mental harm, lost wages, harm to a brand. Those aren't copyright harms. And so the CCB also can't order a party to stop or modify infringement or misrepresentation activities. What we can do is, if the respondent agrees, I will stop my activities, I'll modify them if the board finds that I'm liable. Then if the board does find you liable, the board can make that agreement part of its order. So it might affect how the damages wind up playing out. If you've said, tell you what, I don't think I'm liable, but if you decide I am, then okay, I'll stop, I'll take this down offline, or I'll stop sending takedown notices, what have you. In that case, maybe the board might say, okay, well, you're trying to be reasonable. maybe damages will be a different amount. But as a general matter, the board can't order you to stop anything if you're not going to agree to it as a part of the final determination. That's different from federal court, where the courts can do what's called injunctive relief, exactly that sort of thing, telling people they've got to change their behavior.
Okay, so now that we know what type of claim we're going to file, the type of proceeding we want, and the amount of damages we're seeking, we're ready to file. You can file claims through ECCB, which is the online filing system for the CCB. Participants can register for ECCB to file, respond, receive, and review documents related to their proceeding. To register for ECCB, you'll need a login.gov account. If you've ever applied for a federal job on USA Jobs, or if you applied for pre-TSA PreCheck, you already have a login.gov account. Anyone can view unrestricted documents through our public case search feature without registering. So we're going to review our example from earlier. Dan has gathered all of his information about his copyright infringement claim, and he's ready to file. He's decided to file a standard track proceeding in this case. So the first thing we're looking at some cropped screenshots from ECCB. First, Dan will be asked to select the type of proceeding. As I mentioned, he selected standard track. He's going to enter in that contact information we've been talking about, his contact information, the respondent's contact information. Then he's going to be asked about his work. So as you can see, Dan has registered his work, My Life in Vinyl. He received a registration from the office. He's described his work, and he's certified that he's the legal or beneficial owner. Next, he'll be asked those important details about the exclusive rights at issue in the alleged infringement. So while Dan was gathering his information in preparation to file, he also discovered that MB Publishing has huge excerpts of his book up on their website. So he's checked distribute copies of the work and publicly display the work from the wrongful activities drop down. He's selected that the infringement is still ongoing. That information is still up on MB Publishing's website, and he's let us know where that infringement is occurring online. Further down in the claim form, Dan will be prompted to give the details about his dispute. As we mentioned earlier, Dan has included necessary details, including how the respondent had access to his work. It was widely published. He went on a huge book tour. He assumes that everybody must have known about his book. And he also included information about how his work is substantially similar to the book on MB Publishing's website. In this case, he said they are pulling direct copies. That is chapter 2 of my book just hanging out online. Dan is going to then add any supplementary documents that he would like to add, pictures of the infringement, so screenshots of the book up for sale on the MB Publishing website, and he's going to pay his $40 filing fee.
So once you've filled out that claim form, you're initiating a proceeding. And so the next step is one of the big ways that claims are streamlined in the CCB. It's called compliance review. And this is what Maya and I have spent a lot of our last 6-7 months doing. When a claim gets filed, it goes to a copyright claims attorney. That's me, Maya, and Whitney Lewandowski. And we review the claim to make sure that it complies with the requirements of the Case Act and the CCB's regulations. So let's follow the two branches here. Up top, if we review the claim and it's compliant, good to go, great. We'll file a notice of compliance telling you time to provide the respondent service, which is a term for a formal way of delivering legal papers. So you'll have 90 days to serve the claim and an initial notice. There's a few ways you can do that. Generally, it depends on the law of the state that you're serving in. And for example, you could hire a process server, find someone else who can serve the documents. Once they're served, you file a proof of service, which is a document that explains how the papers were served, just a page. And then it's time for the respondent to figure out what to do next. On the other hand, the other branch here, if it wasn't compliant, we'll tell you why, and we'll tell you what you'd need to do to fix it. If you get an order to amend the claim, you'd review that, and then you get another shot. You've got 30 days to file an amended claim that would fix the problem. If you do, back up to the top branch, it's service time. If you don't, you still get a third shot. We'll explain again, here's what's still wrong, here's what you would still need to fix. If After that third shot, a copyright claims officer confirms that it's still not compliant. On that third try, your claim would be dismissed without prejudice, which means that you could refile it again if you fix the problem here in the CCB, or you could file it again in federal court. So those are the basics of the branches. The next interesting thing is what happens when it gets into the respondent's hands. So if the CCB finds you've got a compliant claim, you're a respondent. When you get served, you have 60 days to decide whether to opt out or not. If you don't opt out, it's going to be an active case and we'll issue an order on the next steps. That's when the claimant pays the rest of the initial filing fee, completes the $100 filing fee. And that's when the respondent signs up for ECCB, so we can send notices to both parties. If you do opt out, the claim against you is dismissed, and the claimant could raise it again in federal court if they so choose. So it's totally up to the respondent at that point. If the claimant refiles in federal court, you're facing a longer and more involved and more expensive proceeding, potentially more in damages, maybe having to pay more fees, paying an attorney, and you wouldn't necessarily have a copyright specialist deciding the case. And if the claim stays in the CCB, you'd be able to raise any defense that you would be available in federal court. Then again, if you're a respondent and you opt out, the claimant might not refile in federal court at all. So you've got some risks to weigh, and the decision's up to you.
Okay, so we're back at our example, but let's look at it from the respondent perspective. Maya, who is the owner of MB Publishing, was served the initial notice of Dan's claim, and I ignored it. But when I received a second notice from the CCB, I realized, okay, this might be a big deal that I need to pay attention to. I believe that Dan is wrong about the infringement, but I don't want to take the chance that Dan is going to go to federal court and get those higher damages he talked about earlier. This is a key difference from federal court that we want to highlight. As the owner of MB Publishing, I can represent MB Publishing in the CCB without having to get an attorney. Before I file my response, there's a couple things that we need to think about. If you should review the claim carefully and think through what the claimant is accusing you of, the facts and arguments that they're making, the evidence that they have included, and whether you would describe the events differently from the claimant's version of events. In our example, I could remember that I had a license to post Dan's book, and that's why I thought it would be okay. Filing your response is the first thing that a respondent is going to do in a proceeding. It's your first opportunity to respond to the allegations the claimant has made against you and raise defenses that you have to those allegations. You'll need to file your response through ECCB by the deadline listed in the scheduling order, which will usually be about 30 days from when the schedule was issued. Something that Dan also touched on was counterclaims. I could consider if I had a counterclaim against Dan, maybe he's infringing one of the exclusive rights that I am the legal or beneficial owner of. If you're a respondent considering filing a counterclaim, you must do so at the time of your response. So that's why it's really, really important to think through your side of the dispute once you receive notice of the claim. The CCB can consider the following types of counterclaims. We can consider counterclaims related to the same facts and circumstances that are the subject of the original claim. So what does that mean exactly? This means that you cannot add unrelated claims to an existing CCB proceeding, even if they are against the same claimant. So in our example, I can't add any claims about infringement related to Dan's blog because our claim is really about Dan's book. And those two instances likely involve different facts and circumstances. The CCB can also hear counterclaims on a contract, such as a licensing agreement that permits the respondent to use the disputed work that affects the claimant's asserted rights in the original claim. So we're back at our example, and I submit a response to Dan's claim on behalf of MB Publishing. The response is going to give my side of the claim and include details about the licensing agreement that I mentioned, and just state that I believed he had permission, that I had permission to sell the book. I've decided not to file any counterclaims against Dan because I really just want to get this process over with, and counterclaims can add some additional time to a CCB proceeding. And I decided that I just really want Dan to go away. So I've decided to file a response that doesn't include any counterclaims.
Okay, Maya, okay. Well, so once the response is filed, and if there was any counterclaim, any response to that is filed, then it moves to the next stage, which is the officer presiding over the claim will hold a pre-discovery conference just to sort through what comes next, make sure everyone's on the same page, everyone knows what to expect. Anyone who has any particular issues with this case can raise them then. And then it moves into discovery, which is the stage of the proceeding where everyone involved exchanges information and documents about their claims, their defenses, any counterclaims. Discovery in the CCB is much more streamlined than what you go through in federal court. It's radically different because there are only very specific types of claims that get heard here. It's not one party asking the other party for everything under the sun, and then the other party objecting, oh, that's not appropriate, that's too much, it's going to take me forever to dig that up, and a lot of back and forth fighting. There's a standard set of document requests that get issued to both parties based on the claim. If you've got an infringement claim, here are the documents you'll need to produce, and a standard set of interrogatories, which are just questions to lay out the facts of the situation. And so each side answers the interrogatories, produces the documents that are required to the other side. You can request more if there's something that's not on that list that you think this is really important, I need this on the list too. File a request with the board and the board could grant it and you can get a little bit more. But there's no depositions, which are usually the most expensive, one of the most expensive parts of a civil case in federal court. You're not having, having a court reporter take down your notes about the questions and having your attorney object and getting hammered about what the other side thinks really happened. All of the testimony that you're going to submit is just going to be written statements, and there are no third-party subpoenas. If you've got someone else who you know is involved in the thing and they're willing to give you a party statement, a witness statement, then they can give you that witness statement and you can submit it, but you can't require them with a subpoena to submit something. Experts are almost never allowed to testify in the area of their expertise about, how they believe the case should come out. The expert testimony is a common feature of copyright cases in federal court. Unless you can convince the board that it's truly necessary in this claim, it's just usually not in anyone's interest to have an expert involved, because the costs of the expert and of the counter expert who you'd expect to show up are going to swallow up any benefit that you could get out of the claim. So discovery is not where you wind up spending all of your money when you're in a CCB. In our example, Maya and Dan are going to exchange the information and documents relevant to the issues. We answer questions in the interrogatories, and we send each other the documents that we need to. The licensing agreement that was mentioned in the response, my correspondence with the Copyright Office about registering the book, all of that will go in. Each side knows what the other side's story is going to be, what the facts are. And so, each side walks into the final stages of the proceeding knowing here's the basis of the arguments that the other side might make. There are also, I mentioned conferences and hearings, and Maya will discuss those a little with you.
Yeah, so the CCB in this middle active phase can be really customized. Each party can request a conference, and a conference is a conversation between the two parties and their lawyers if they're representative. They have a chance to discuss the claim with the copyright claims officers. Conferences can be held by one or more copyright claims officers, and these conferences will all happen virtually. Hearings in the CCB are possible, but they may not be held in every CCB proceeding. If the CCB does conduct a hearing, it will be done by video conference. And again, each party can request conferences and hearings through ECCB once they're in this stage of the claim. So as we talked about, the middle of the proceeding is really customized, but generally speaking, after the discovery phase, each party will present their claims or defenses to the CCB through written statements and supporting evidence. Any party with a counterclaim can submit a sworn statement on its own behalf or on behalf of from any witnesses. They include documents for the CCB to consider. And a statement is really just setting forth your position on why you think you should win the case. Again, I want to reiterate, this doesn't need to be a legal document. This doesn't need to include a bunch of legalese. Really, we just want you to tell your side of the story. Again, back it up with all of those documents that you might have gotten in discovery, and just really lay out your version of the claim and your version of the events. These filings are the longest filings in a CCB proceeding, and this step also varies based on whether you're in a standard claim or a smaller claims track proceeding. In a standard track proceeding, each party will present their claims or defenses to the CCB through written statements and supporting evidence. In a smaller claims proceeding, the parties submit shorter statements and have a merits conference with a copyright claims officer to discuss the issues of the case. The copyright claims officer will then present their findings of fact, and the parties will have an opportunity to respond if they think that the copyright claims officer got it wrong. So back at our example, Dan and I are each going to draft our written testimonies using the information that we gathered during discovery. I'm going to include all the information I found out about the way Dan registered his book and any other communications about how many books he sold on his site. And he's going to include, I'm going to include the licensing agreement that I think is at issue. Dan is going to include every document he received about maybe how many books I sold on my site. And we're going to include those as exhibits.
Okay, so then everything's been submitted to the board, and after all the testimony is in, if the board has a hearing, then there may be final discussion. But once that's over, the board will issue its final determination, which is put on ECZB in writing, and it's going to include an explanation of the facts and the laws that the board relied on to reach its determination. It can also include, if the parties have agreed, we're going to get rid of some of these claims or counterclaims, we'll dismiss them. The CCB will include those agreed terms in the final determination on request. And the final determination is enforceable in federal court. If you have been ordered in a final determination to pay damages and you don't, then the claimant can take this final determination, bring it to a court and say, this should be enforced. And so they can begin proceedings against you there. So it's in your interest, I think, to comply. On the other hand, let's say that you have an order against you, the case doesn't come out your way and you're not satisfied with the result of the proceeding. There are a few things you can do. You can first just ask the board to reconsider. Go to the CCB, point out a mistake, something that was overlooked. You submitted it in your papers and they just didn't consider it. And so get the facts straight, get the law straight. Maybe it'll change your determination. If you're still not satisfied after that request, you can ask the Register of Copyrights, who is basically our boss's boss's boss. Ask her to review the case and see if she would come to a different conclusion. There's a $300 fee for that type of request, and she would only change the board's determination if she decides that the CCB just abused its discretion, that really there's no way that the officers could have reached that decision correctly. Another option would be to just go straight to federal court, and there you can challenge the decision, but you need to prove something really seriously wrong, that there was a fraud was committed, or the CCB just didn't have the authority to make the decision. Or in the third case, in a default, which is if someone just doesn't participate in the proceeding, and so there's a determination entered against them. If you've been found in default, you could have a court potentially set that aside if you can show that you had what's called excusable neglect, that there was a reason why it makes sense that you didn't respond, whatever that might be.
So we've thrown a ton of information out during this webinar. And if you're like me, you're like, okay, this is great, but what if I need help? The CCB has a ton of resources on ccb.gov to help you navigate this process. The first thing I want to mention is the handbook. The handbook is a step-by-step guide to help participants file or respond to a claim before the CCB. And now the handbook is cut up into separate chapters based on all of the topics that Dan and I have covered. So if you're like me and you're like, I'm not reading anything over 35 pages, the text is too small and I just can't, you can look at the section of the handbook that's directly at issue with what you're working with. If you're ready to file your claim, we have a filing handbook. If you're wondering about whether or not you want to opt out, there's an opt-out chapter of the handbook. If you're saying, okay, I'm at the discovery phase, what do I need to do? There's a discovery chapter of the handbook. Another thing I want to reiterate is the pro bono assistance page. Some lawyers, law school clinics, or organizations may be available to help and provide legal assistance or representation on a pro bono basis, which means you will not be charged for their services. And we maintain a list of these resources on our website. The last thing I want to mention is that you can always email us at asktheboard@ccb.gov. Now, we can't provide legal advice for your particular claim, but we can give you a ton of information about next steps and about the CCB process generally. Again, you can visit ccb.gov for more information. You can also subscribe to our newsnet to get CCB related updates directly to your inbox. And now we're going to start off with your questions.
All right, y'all. So now that we're ready to move into the Q&A section of the webinar, I just want to thank everybody for your attention and also enthusiasm because there's so many questions. We're unable to offer specific legal guidance, but we can answer general questions. We can provide resources. Again, if you have questions, you can always reach out to asktheboard@ccb.gov. And we'll also try to provide some link outs as Dan and Maya go through the questions. So with that, Maya, do you want to take the first question?
Sure. I see a question that came in early about libraries and archives. It says, I've seen that libraries and archives can opt out of a CCB proceeding. Can you please clarify this option a bit? Yes, so libraries and archives have a special preemptive opt-out. Now, if a library, say the Library of Congress has, or your local library, the DC, here I'm in DC, the DC Public Library decides to opt out of all CCB proceedings, they can file a form with us and they are preemptively opted out of the CCB, which means that they don't have to opt out every time they receive a claim. However, if a library or archive does not file the form with us and has not preemptively opted out of all proceedings, they can file an opt-out on an individual basis. So with that, I'll let Dan take the next question.
Let's see, we've got a question that says, can a non-exclusive licensee bring a claim? And there the answer is no. You have to either be the owner, the author, the legal owner, or the beneficial owner of the copyright interests. An exclusive licensee has basically an ownership interest. A non-exclusive licensee, someone who has permission to use the work but doesn't have an ownership interest, doesn't. So that one's a no, unfortunately, for you. The other part of the question, can someone who has acquired royalty rights bring a claim? If those royalty rights are effectively an ownership interest, then yes. If all you've acquired is the right to be paid, but you don't have control over the work and how it's used, then no.
This is a good question. Have any cases actually been decided by the board yet? The answer is no. So as Dan mentioned, we started operations in June. So none of our claims have gotten through that active phase to a decision yet. Right now, we have some cases that just started out in the active phase. So those parties are getting ready to file their responses. That's kind of where we are in the first set of claims that we received. So no, the board hasn't decided any cases yet, but when it does, those decisions will be available for the public to view on eCCB. Dan, do you want to take, we'll take two more. So Dan, do you want to do another one?
Sure. Why does CCB apply to streaming platforms, Spotify, YouTube, Facebook? The answer would be because infringement happens there and bad infringement claims happen there. And so if that's where things are happening and you've got a claim about your copyrights, you can bring it here.
Oh man, this is moving so fast.
You want to take another?
Yeah, let's take one more.
Ooh, I see one.
Oh, yeah, go for it.
Can the declaration of non-infringement include an argument of fair use? Yes. Can the CCB decide whether fair use is valid, or does that have to go to federal court? Yes to the first part. It doesn't have to go to federal court. The CCB understands and applies the law of fair use just as a court would.
Yeah. So I see a ton of great questions still in the chat. Please know that you can always reach out and ask your questions to us at asktheboard@ccb.gov. And so with that, I will kick it back to Holland.
All right, Dan and Maya, thank you so much for your time. And everybody, thank you so much for joining. If you liked this event or have suggestions for how we could make it even better, please feel free to let us know in the Survey Monkey link that I just popped into the chat. And if you have questions, you can always reach out to asktheboard@ccb.gov. Lastly, I should say lots of y'all asked about recordings of this event or PDFs of the slides. PDFs will be available at copyright.gov/events in the next week or so. We'll also be posting a recording, although we need to make sure it's closed captioned for accessibility, and that can sometimes take a couple weeks. So thank you again. Really appreciate everyone's time.